Hello, and welcome to today's Law Awareness Weeks at CDC 2020, The Law and Me, Stronger Together, organized by the Law Society Pro Bono Services Office and the 5 Community Development Councils, supported by People's Association, National University of Singapore Faculty of Law, Singapore Management University School of Law, Singapore University of Social Sciences, and the Singapore Corporate Counsel Association. I'm Alex Liam, your host for today's webinar on dealing with creditors, individuals and businesses. Just some housekeeping before we get started. Point 1, relevant materials for today's talk can be downloaded from the Hands Out section, which you can see on your screen. If you are using a mobile phone or tablet, the icons should appear on your top right-hand corner. On your computer, you should see the icons on the right-hand side. Please download these useful materials before the end of the talk. Point 2, feel free to ask any questions during the webinar. You can type them into the questions section and click send. Your questions will only be seen by the organizer. We will do our best to address them during the talk or at the end of the talk. Please note that the discussion and any material provided in this webinar is not intended to substitute or constitute professional legal advice. You should consult a lawyer if you require specific legal advice. All right, with that done, let's get right into the discussion. With us today, our panelist is Mr. Gregory Vijayendran, SC, the President of the Law Society and a partner from Rajah and Tann LLP. Gregory, thank you for joining us today.
Thank you for having me, Alex.
Right to it. Oh, thank you, Gregory. Let's get right to it. Greg, could you shed some light on who is a creditor?
I'll be pleased to. A creditor is any person, natural or artificial, individual or corporate, who is owed a debt. A debt is a precise monetary sum that is fixed and ascertainable as a matter of arithmetic. It is to be contrasted or distinguishable from damages, which is an estimate of losses to be proven in a court of law based on evidence. Creditors can be financial institutions or banks, licensed and unlicensed moneylenders, family members even, or friends. And if owed money, they are entitled as a matter of law to initiate court action for an unpaid debt against the debtor, who is the party owing the debt. The creditor would typically issue a letter of demand before starting the court case or legal action, giving a certain time period. It could be 7 days, 10 days, which is convention. Sometimes in exceptional cases, it would be shorter. And that gives the grace period, as it were, for the debtor to pay up. If not, you would face the court proceedings. If the letter of demand is not honored, then the creditor can escalate the matter by filing a case in court against the debtor. And such a case, which is known as a civil claim or a civil case, is typically initiated by way of a writ of summons. That is the form of proceedings it would take in the usual cases.
All right. So when something like this occurs, how should we respond to the situation?
So to answer this question meaningfully, Alex, I think we need to view this from the lens of the debtor. So we flip things around and look at it from that perspective. And so if you wear that hat, you would first receive that writ of summons that I mentioned in my last answer. And in civil procedure parlance, that is called service of the writ of summons, which is essentially the method of delivering the writ of summons to the debtor in a way that is recognized by law, in a way that is valid according to civil procedure. Typically, it's by way of personal service, That's the convention. However, in some cases where you cannot find the debtor, then you would resort, from the creditor's point of view, to an alternative means of drawing attention of the debtor to the court process. So typically the creditor who tries to locate the debtor, tries to serve him or her, if it is an individual, personally fails, they would apply to court for what is known as substituted service, and would ask the court for leave to be able to have the writ of summons served to an alternative means, whether by way of, for example, posting to the last known address, or taking out an advertisement in the newspaper, or some other creative ways, which is sufficient to draw the notice of the debtor to the court proceedings. Now, once the debtor is served with the writ of summons, then they will need to file and serve a document called the Memorandum of Appearance. MOA is the acronym there. Memorandum of Appearance is a court document which signifies an intention to defend the court proceedings. There are some cases where the debtor may not do so, and so a creditor is able to get what I call a technical knockout by way of judgment in default of appearance. And so you shortcut the whole process, and so you would get that judgment. But in situations where the debtor, who is of course by then the defendant in the court proceedings, the creditor becoming the plaintiff in the court proceedings, is served with the writ of summons, they file that memorandum of appearance, which signifies the notice of intention to defend. They will then set the stage to live to fight another day, and to set the stage for their own defense. They have to file and serve this memorandum of appearance within 8 days after service of the writ of summons, and thereafter they have a fortnight. The defendant, the debtor, whether individual or institution, will have 14 days thereafter from the time limited for appearance, entering appearance, or from the time the creditor's statement of claim has been served on them, to file and serve their defense to the court proceedings. And the defense will essentially respond to the claims made by the creditor in a document known as the statement of claim, which is attached to the writ of summons. And so the defense will respond paragraph by paragraph, both in terms of what is asserted and to set out the version put forward by the defendant debtor.
Thank you very much, Gregory. I think before I get to the next slide or the next topic, I think crucially, could I just ask if, I think this is a question that maybe on some of our listeners' minds as well, is it possible to have represent yourself? I believe in all of this, you could do it via self-representation. You won't really need a lawyer to go through the civil procedure, or you can do it either self-represented or you can do it with a lawyer representing you. I think that would be the case, but it would be great to hear your any pearls of wisdom on this. All right, thank you, Gregory.
Sure, I'll be happy to share some perspectives for consideration. And that's a good question too, Alex, because I think it really drills down further into the question of the level of court involved and the nature of the proceeding. So for very small claims, you have a small claims tribunal, which has jurisdiction to hear claims with a quantum of $20,000 and below, amended as of last year, end of last year. And it can go up higher to $30,000 with agreement by both parties. For small claims tribunal cases, typically the parties self-represent. Lawyers are not allowed to be present. The claims are very small, and legal costs would, easily eat up a fair amount of any recovery. So it does make sense that, for straightforward claims, litigants should rightly be in person, self-represent, and that's also the mandated process. Then you go up higher to the magistrate's court, which has a jurisdictional limit of up to $60,000. It can hear claims up to that amount. And then From 60,000 to 250,000 is district court. Anything above 250,000 is the high court. And so those are the stratification or tiers of court jurisdictional limits for debts. At every level of the court proceeding I've just mentioned, magistrates court, district court, even for the high court, when it comes to individuals, you can always self-represent. You can be a litigant in person. It will not be easy. You need to weigh whether it's something that you would benefit from the counsel of counsel who is appointed to advise you on the merits of the claim, and whether or not you can mount a meaningful defense based on the contract. I'll give you one example, which is, for example, it's something that may look straightforward, like a loan could have a meritorious, not unmeritorious, but meritorious defense of money lending, which could be a complete answer to the entire claim. And so you would benefit from having a counsel, lawyer looking at that matter. There are other things that are straightforward. You owe money. Frankly, you're only trying to negotiate for a discount or for installments, deferred payments, and so on. So you need to assess for yourself whether it's straightforward. You really don't think you want to incur more costs unnecessarily. Although even in such cases, sometimes you could benefit from appointing a lawyer to negotiate for you, and the value proposition comes in that way, rather than stalling for time and delaying the inevitable. So I think that would be some considerations that you would sort of take into account. I would say the more complex the case, and certainly when you get into high court territory, more than 250,000, district court claims as well, in many cases, you would be handicapped without the benefit of counsel to navigate through the court processes and the procedures involved, especially if you're going to go the whole hog all the way to trial. A number of magistrate court cases as well, sometimes the complexity, you can do a DIY, but there will be challenges to try and sort of understand the terrain, even with the DIY tools and the information and knowledge that you may have and you may feel confident about.
Thank you very much, Gregory. I think those are all very good points. I think you've also covered quite a bit more of what I wanted to cover next, but basically, could you enlighten us as well on what happens during civil proceedings that follows the filing of papers? Maybe just a brief summary would do.
I'll do that without turning this into a sort of a full-blown lecture. So here's the summary version or primer. After the writ of summons, and I made reference to that, which essentially is the head document, and it incorporates the statement of claim, which sets out all the material facts giving rise to the claim, and it ends off with the tail, which is the prayers of relief. And I also mentioned the defense, which responds paragraph by paragraph to the statement of claim. And then typically after the defense is filed and served, 2 weeks thereafter, there will be a reply filed by the plaintiff, and that will respond to the defense where it needs to respond to the defense. And so those are the main pleading documents. After the close of pleadings, what happens is if there are portions of the statement of claim, defense, reply, which may be vague, which may be ambiguous, which may be unclear, which may require more particulars, then the parties try and sort that out, because the lawyers will try and ask for what is known as further and better particulars, so that you know the case that you need to meet, and so that you would be able to understand more fully the nature of the allegations that are put forward. So that resolves pleadings, it resolves particulars. Next step is actually what is known as discovery. Discovery is exchange of documents. So if the matter isn't resolved earlier, for example, by way of summary judgment proceedings, which cuts short those proceedings and results in, say, for example, in a clear claim, a win for the plaintiff, and you don't have to go all the way to trial and have witnesses testify and so on, because you can win the case on the basis of documents and just have sworn evidence statements which depose to the main features of the claim, then you don't have to go the whole hog. But for cases that are going to go all the way to trial, there will be this exchange of documents, and discovery is the name of that process in civil litigation. Discovery, as its name implies, is what you discover from the other side. And so everyone needs to put their cards on the table, so to speak. Disclose the good, the bad, the ugly. You can't hide documents. You can't play an ambush game and say, let me sort of throw this card in at trial. You disclose everything. And so that allows both parties to appraise both the strengths and the weaknesses. And in many cases, there's a resolution after that. Now, if there's no resolution, it goes further. And then it becomes, the next step, which is affidavits of evidence in chief, which is sworn statements of evidence from the witnesses who are going to give evidence at trial. So that's sewn up, exchange, and then you go for trial. And then go for trial, the witnesses who have given the affidavits of evidence in chief will need to appear to be cross-examined by the opposing counsel. Judge hears the evidence, considers the evidence, including the documents which have been admitted into evidence, and then hears submissions on both sides and gives you a judgment one way or the other. So that's typically, in a nutshell, what happens. There are some other nuances involving dispute resolution. I'm happy to cover that at an appropriate juncture.
Thank you very much. So now that we are able to better understand what happens in a civil proceeding, what could possibly happen if the judge rules against the debtor and a judgment debt is owed?
So if a judge rules against the debtor, then what is a claim becomes a judgment. What is a claimed amount becomes a judgment sum for the principal amount, which would be what would be the debt claim that you're trying to recover from the debtor as a creditor. And so apart from that sum, the judgment sum for the debt, you would also be able, in a number of cases, ordinarily to recover interest, and interest would be also part and parcel of the judgment sum for being kept out of the money when you were rightfully entitled to it. So it's for loss of use of funds, and you would get some interest on it. There is also interest payable after the date of judgment. So the longer the debtor, who by now, after judgment, becomes the judgment debtor, just as the plaintiff, after judgment, becomes the judgment creditor. So if the judgment debtor doesn't play ball and honor the judgment and drags it out, interest is also running on the judgment sum to the tune of 5.33% per annum. And so, you will just add that on to the bill from the judgment creditor's point of view. And so that's what will happen if the judgment creditor is not able to ascertain what assets the judgment debtor has. They could apply to court to examine the judgment debtor on the assets, the property that the judgment debtor has. This is a cross-examination under oath. And then once they get those answers, they can then go for broke in the sense of trying to pursue other means of enforcement against the judgment debtor. And so I'll stop there unless there are some sort of further follow-on queries on the immediate enforcement aspects of the obligations after judgment.
So I think naturally, taking things a step further, what if the creditor then ascertains that the debtor has sufficient assets, right? And in such situations, what action can the creditor take?
Yes, so that's the logical follow-through, Alex. So I mentioned this examination of a judgment debtor. That's only a means to an end. It's in cases where you have no clue, even with all your asset tracing initiatives and whatever is publicly available by way of searches on the judgment debtor's property. You draw a blank. You would actually do the hauling up to court. Effectively, it's like an interrogation. The answers are recorded. It's really cross-examination, and you will ask for documents too in order to ascertain assets. But to answer your question squarely, if you actually do know what assets the judgment debtor has, then you can enforce your judgment in the following ways. So the first way is the writ of seizure and sale. There can be a writ of seizure and sale on movable property, and there can be a writ of seizure and sale on immovable property. with one wrinkle on the analysis of the second part that I just covered. I'll come back to that. So writ of seizure and sale on a movable property really is a seizure where you would apply. You can do it on the quiet. You would apply the bailiff from the court will go down and seize, tag all the movable property that may be found in the house of the judgment debtor, and will essentially seize them. And time period is allowed for someone to dispute ownership of that item, and you typically see a husband-wife, sort of claims there, or maybe even third-party claims, for example, hire purchased items and so on. But to put it simply, after seizure, typically that would lead, unless there are third-party claims and so on, it would lead to sale, and sale is by way of public auction. And so once that's realized, a pot of money comes back in, which is then, after deducting all the expenses, sheriff's expenses, auctioneer's expenses, and so on, you would then pay off the judgment creditor. By a parity of reasoning, the same process is also applicable for immovable property. But I mentioned a wrinkle because HDB properties cannot be seized pursuant to this writ of seizure and sale process. If it's private property, the answer is yes, and so you would seize it. But of course, it's a different type of registration of that writ of seizure and sale, but it can be the prelude to an auction. So that's the first way, writ of seizure and sale, or WSS. Oftentimes preferred by judgment creditors because you can move in very fast. It's not very costly. You can do it stealthily. Now, the second mode is what is known as garnishee proceedings. Nothing to do with food or garnishing, even though we're nearing dinner time, but garnishee proceedings are really attachment proceedings. And what happens is the judgment creditor will attach bank accounts in the main. So for example, if you know that this judgment debtor has got a bank account, a fixed D account, savings account, and so on, you would serve the garnishee papers on the bank. And the bank, once it's served, with the garnishee papers, will essentially freeze the account at first instance. Later on, they will write to the judgment creditor and say how much is in the account. And once the garnishee order becomes absolute or final, they will then pay out those sums not to the judgment debtor, but to the judgment creditor. So you're seizing the debt and saying, pay me instead, the judgment creditor. The third way, which is a bit more unusual, is appointment of receivers to obtain, some type of, for example, income on a judgment debtor's assets. If, for example, their rental income being enjoyed and so on, you could do that. There's some other rare ways of seizing shares as well. I won't go into that. Those are three of the main ways that I would offer you in response to your question. And these are the modes you would explore before you come to the last resort, which I think we'll talk a little bit about.
Sure, that sounds great. There was a question that was posed by a listener, and it's quite a good question actually. So basically, the question is, there is a risk that the debtor has no assets available. So does that mean that the creditor might have to bear the cost of the examination of the judgment debtor? So I think the question is basically asking, is it the case that if, let's say, the debtor has no assets available, will the creditor then have to bear the cost of the examination of the debtor? I'm sure you can shed us some light on this. Thank you, Gregory.
Yeah, so, sure. So these are fact-specific inquiries in the sense that the court still retains a discretion on the question of costs, that might be payable for that examination process. If, for example, a judgment debtor is playing games, refusing to play ball in terms of disclosing documents, trying to, ask for adjournments to get information for the examination of judgment debtor process, submissions can be made that the costs of that hearing should be borne by the judgment debtor. And so it doesn't follow like night follows day that even if, the debtor has no assets, the costs must be borne by the judgment creditor. But having said that, if the judgment debtor has got no means to pay that costs order, it is true that by engaging a lawyer and embarking on that process, the lawyer will still be looking to the client to cover some portion of costs for that examination of judgment debtor. So you may end up, for want of a better expression, throwing good money after bad. You take the risk that in that examination process, it comes to naught, you recover, you might get no meaningful intel or information, and then you end up picking the bill up later as well to pay your lawyers. So I made the point about cost being in the discretion of the court, but I also wanted to make this pragmatic point for consideration.
Very fair point, Gregory. Thank you for that. All right, so moving on. Basically, bankruptcy is usually seen as a last resort when large sums of debts are unable to be paid back. Could you share with us more about what bankruptcy actually is and what it entails?
I'll be pleased to, and I was alluding to this earlier. Now, what we have to remember is that all the modes that we touched on in the last answer, WSS, garnishee, receivership, and so on, are modes in which the judgment creditor will enjoy the fruits of that singly, and to the exclusion of anyone else. So, you know, if I attach that account and it's successful, I will be able to either pay off or reduce the amount owing to me. So, you know, it becomes, in some cases, a race among the creditors to see, you know, who recovers how much and how fast. And those may be cases where, you know, a judgment debtor owes money to multiple parties. Now, in sharp contrast, bankruptcy, which is often the last resort in terms of consideration of options, some people still consider that it has got its efficacy, especially if there's a threat of bankruptcy. From a creditor's point of view, sometimes by having the threat, you may think it's a pressure point, and the judgment debtor will then start to squeeze finances, beg, borrow, hopefully not steal, to get some money to pay off that judgment sum, so that, you know, he or she or you know, the individual involved actually will not end up with a bankruptcy order made against them. Bankruptcy is, of course, in relation to individuals. For companies, it is winding up or liquidation. So I will just answer it squarely according to what you asked, which is bankruptcy. So bankruptcy is essentially the legal status of an individual who is unable to pay his or her debts as they fall due, based on a judgment sum. In some cases, you know, people may not necessarily need to go all the way to a judgment sum, but they will just rely on a statutory demand to trigger and rely on some of the presumptions to make out their case and go for broke. But if there is a disputed debt, it ends up in a court case. So the debts involved will have to overtop $15,000, which is, you know, the current sums. Of course, with the nuance that we need to be aware of, which is that under the COVID-19 Act, which takes precedence until 20th of October 2020, so from 20th April 2020 to 20th October 2020, the monetary threshold to commence bankruptcy proceedings has been lifted to $60,000. So one needs to bear that nuance, but it's temporary. And so with a bankruptcy status, the judgment debtor, if a bankruptcy order is made, becomes a bankrupt, and, you know, technically is known as an undischarged bankrupt. So the undischarged bankrupt will be subject to severe restrictions. These include travel restrictions, and not just because countries are not receiving us due to COVID-19, but these are restrictions that bar that individual, so they're individual specific, bar them from traveling. They cannot travel, you know, unless they get permission from the official assignee and public trustee's office. There are credit restrictions. Who's going to lend money to an undischarged bankrupt? You know, no FI in their right minds would. And then they, you know, will not be able to act as a director. They will also be disallowed from managing businesses, and so on. So these are all very severe disabilities or disqualifications, which will affect that individual concerned. What should also be noted is that all the assets of that particular individual will then statutorily, automatically vest in the official assignee and public trustee by reason of the bankruptcy legislation.
Thank you very much. So I understand as well that there are usually procedures that one must complete to file for bankruptcy. Could you just run us through the process?
Certainly. So filing for bankruptcy, essentially by way of, essentially putting the court papers together, preparing them, double checking them, verifying them, and then filing them in court, does not necessarily mean that the person will be automatically declared a bankrupt. So the way that one needs to do so still involves a court hearing, and so the court is still a safety net, so that the bankruptcy order will ultimately be made by the court. There are relevant forms that would need to be completed from the Ministry of Law website. I think there is a helpful link that could be accessed as well, and that would help someone, for instance, who wants to self-declare that they are bankrupt. This is rare, it's exceptional, but there are some debtors. In one case that I did, a debtor wanted help to file bankruptcy application. Why? Because she was hounded by creditors everywhere, and the creditors didn't want to file bankruptcy proceedings. So we helped her to file a debtor's bankruptcy application so that she had the peace of mind, and she would then have the bankruptcy status and not be troubled by all these creditors chasing her, because the creditors can no longer pursue the enforcement steps that I mentioned earlier. So there would be various other forms that one needs to complete. Now, the other thing that you can do if you are an individual is, of course, to go to the Supreme Court's legal registry, make payment to the Commissioner of Oaths for Commissioner of Oaths fees, because an affidavit, which is a sworn statement, will need to be sworn before a Commissioner of Oaths. And because bankruptcy hearings are heard in the High Court as well, that process will need to be completed in the Supreme Court at City Hall. And so as an individual, if you need help, to try and file those court documents through e-litigation, you can proceed to the LawNet Service Bureau and pay the prescribed fees and complete the process online. Then the court will issue a hearing date, and then you need to attend the hearing as a judgment creditor. Now, all that, of course, presupposes you're acting in person. If you're acting through lawyers, then the lawyers will sort out all the paperwork for you and inform you about the hearing date.
Thank you very much, Greg. Just for the benefit of our listeners, if you really want to find the MinLaw link for the bankruptcy forms in a easily accessible way, you could just Google Ministry of Law bankruptcy forms, and the link that Greg was referring to earlier will come up as the first search entry. All right. All right. So thanks for simplifying the process for us. After attending this hearing, does it mean that the applicant is automatically declared a bankrupt?
Yeah, so that's a good question. Even though it looks very commonsensical or intuitive that, look, here's a judgment sum, you didn't pay up, the court had asked you to pay up, and there's no good reason, so it should follow automatically that you should be declared a bankrupt. Contrary to misperception or the common perception, that's not the case. The court will still have to apply its mind on that bankruptcy application to see whether it's appropriate to adjourn the bankruptcy proceedings. For example, if the bankrupt says, look, I need some time, I'd like to be able to make a proposal for consideration by the judgment creditor, bearing in mind that this is a last resort, bearing in mind the serious consequences that follow on from bankruptcy that we touched on earlier, the various disabilities and disqualifications. And to be frank, there's a stigmatization as well. There's no secret about that. And many people live in shame when there's a bankruptcy order. So I think the courts will apply their discretion, whether to adjourn And if the papers are not in order, and in some cases they're not in order, they will dismiss the application on a procedural point. So they will scrutinize everything very carefully. And so it's important from the point of view of the applicant to file documents accurately, cross the T's, dot the I's, and then be able to present to the court the case as to why there is non-satisfaction of that judgment debt, and you do that also by way of affidavits and so on. But if the judgment debtor is trying to offer a compromise to secure or to compound or to kind of come up with a plan, the court may, in certain circumstances, consider that and also assess genuinity and allow for an adjournment to see whether a proposal can be put together to assuage the concerns of the judgment creditor. And so if, however, for example, there's a technicality, and you may remember I also alluded to the fact that in some cases you may not need a judgment debt to proceed with bankruptcy proceedings. You could have a statutory demand. Statutory demand, we didn't go there, it's a lot of detail, could give rise to a presumption of inability to pay debts. But the debtor, and it's not a judgment debtor, it's a debtor, may dispute that he or she owes that debt. And so you end up with a disputed debt. The court takes a look at it and then decides that, no, I don't think it's a clear-cut debt. They may dismiss the bankruptcy application because it's not satisfied that a judgment debtor owes the debt. Or that, for example, if there are means, whether the judgment debtor is truly unable to pay the debt, may be a live question, so it may not necessarily result in the end game of bankruptcy proceedings and bankruptcy order being made.
Thank you, Greg. Okay, so now we can see that there are multiple outcomes to a bankruptcy application. But what happens when the court decides that one should be declared a bankrupt?
Yeah, so it's a sad day from the point of view of the judgment debtor. He or she will find that their life has changed. And it's also something that's very real from the point of view of the emotions. We know that from cases we've done as well, acting for both creditors as well as debtors who are in that boat. But once the bankruptcy order is issued, that notification will be published in the Government Gazette. Of course, if the official assignee will be appointed as the trustee in bankruptcy, deems fit, it may even be published in the local newspapers. The official assignee is like the manager to the bankruptcy or the trustee in bankruptcy, and they will thereafter act as the interface with the creditors. And you may now appreciate more fully the point I made about why there can be some rare situations where the debtor wants the peace of mind instead of being hounded and may self-apply to be a bankrupt. Because the creditors can no longer use bilateral means of enforcing against the bank accounts, the assets, and so on, because all the assets, as I said, will statutorily vest in the official assignee and the public trustees position, office. And so what will happen is the official assignee will then act as the interface. They will assist the bankrupt in terms of dealing with their financial affairs. The bankrupt will have to fill up a statement of affairs. And of course, if there is a happy problem that things are going very well and the bankrupt is able to be discharged from bankruptcy, they will also assist in that process to help extricate the undischarged bankrupt from that status to be then discharged from bankruptcy.
Well, the OA sounds almost like a very undesirable financial consultant, if I could say that.
Yeah.
All right. So could you maybe also share more on how a declared bankrupt has to liaise with the OA after the bankruptcy order has been made?
Certainly. So the adjudicated bankrupt has responsibilities of cooperation. And it's important from the bankrupt's point of view to play ball from the word go. because that will be taken into account. You know, these are the things that you may not know it will be part and parcel of the overall assessment of the official assignee in deciding whether to apply for discharge, the way in which you've cooperated. And so the adjudicated bankrupt will attend at the official assignee's office for a briefing on their responsibilities as a bankrupt. They must also submit their statement of affairs to the official assignee within 21 days from the date of the making of the bankruptcy order. Statement of affairs will, you know, enumerate the assets, the liabilities, and so on, and has to be answered truthfully. You know, in addition, they need to attend at the official assignee's office to work out the monthly installments that they can afford to pay to that office, or to what is known as the bankrupt's estate. And this will take into account, you know, how much they're earning, how much they need to set aside for family, their personal needs, and so on. And, you know, out of what is left in terms of the kitty, it's then paid to the bankrupt's estate. And these, of course, make sense in situations where the bankrupt is employed, not unemployed. So by paying those monthly installments, all of that will be totaled up, aggregated, and will then be distributed ultimately as dividends to the creditors. Creditors may not recover 100 cents to the dollar. They may recover sometimes maybe even 1 cent to the dollar, 2 cents to the dollar. But, you know, all of that payments will go into the pot. And so the amount of monthly installments, the frequency of payments will be factors that the official assignee will consider ultimately in deciding whether that person should be discharged from bankruptcy. And there's also a requirement of periodic accounting.
Okay, so what happens to the bankrupt's assets then, bearing all that in mind?
Yes, so I made the point earlier, but it's worth reiterating. All the property becomes automatically statutorily vested in the official assignee. That includes movable and immovable property. And so the OA, PT, official assignee public trustee for short, will then have control over those assets and will decide how to use such assets to pay off the creditors. So if, for example, it involves shares, if it involves real estate, the official assignees and public trustees office will then have to realize it, you know, in terms of its value, you know, to try and fetch a reasonable amount, which will then go into the pot of money that will then be paid off to the creditors according to various priorities of distribution, which we can talk about later. However, the HDB flats are ring-fenced, they're sacrosanct, they can't be touched, and they don't form part of the bankrupt's estate, let alone vesting in the official assignee and public trustee. Likewise, in respect of CPF monies, they are also ring-fenced from forming part of this estate.
I think one more question that might arise, and I think this might be relevant for our listeners, is that what happens to jointly held assets, right? Because you may have some assets that are held jointly. What happens to those assets when you become a bankrupt?
Yeah, so that's a good question, and it's also you know, a complex question, because, you know, you could say that on principles of survivorship, the joint owner ought to owns everything as well, you know, and I think those give rise to you know, tricky situations for consideration. At one level, one could contend that, you know, you have a type of severance that may arise out of the act of bankruptcy itself, and so in some other cases, the position may be a little bit more gray, because although there is technically you know, severance of the joint property, and you know, so effectively kind of treated as severing the rights that the joint owner might have. In some other cases, it may be a case that the bankrupt actually had contributed all the share for that jointly held property, and so even the joint owner's share actually should rightly be part of the estate. So some of these are also fact-specific inquiries. The effect of severance, of course, is to convert a jointly held property into shares, tenancy in common, which would be either 50-50 prima facie or according to the shares that have been contributed.
Understood. Thank you very much, Greg. All right, so we have a scenario for our listeners, and this scenario is an interesting one regarding bankruptcy. The scenario basically is, I'll just read off quickly. Melvin, this fictional character, has been declared a bankrupt. However, he hopes to get more privileges, such as going for a short holiday nearby, or for the official assignee to view his case more favorably. So what can he do? I think what we kind of want to know is, are there ways that Melvin can travel? Perhaps he can even get discharged from his bankruptcy even earlier?
Yeah, so those are the practical ways. Of course, in our present COVID times, one wonders where he can holiday to. So this is truly a hypothetical. So I would say this, he would need to fulfill some requirements in order to be considered what is termed in a sort of shorthand way, a green zone bankrupt. So in order to get there, he has to play ball. You may remember I mentioned the point of cooperation, statement of account, the statement of affairs filed on time. He's gainfully employed, regular in making installment payments, and servicing that the installment payments are reasonable as well, having regard to income and needs of family. Has timely submissions of income and expenditure statements. Is generally cooperative. Has no pending warrant of arrest. For example, if he tried to travel without getting permission of the official assignee. There's no pending criminal case. There are no bankruptcy offences under the bankruptcy legislation, and has come clean about his assets, local and overseas as well, to the extent that the judgment creditor says, look, we've got all this entail, he's got assets overseas, or he's squirreled some other assets elsewhere. All these are taken into account. And so considered in the round, holistically, then, when these sort of various boxes are ticked, you could say he would qualify on the basis of being in the green zone and has higher prospects of this short holiday being approved, and may be granted a travel permit of more than a month to any country, and so could even go for a longer holiday, not just a short holiday. Now, the second part of your question about could he get discharged from bankruptcy even earlier? The answer is yes. The bankruptcy case could be reviewed, after a time period, 5 years, to assess for suitability for a discharge. He could even be discharged from bankruptcy earlier than he expects. And so those are certainly things that can be considered. But a lot of it will turn on the amounts that he's paid, the amounts that he's owing, the cooperation, no criminal offense, and candor in terms of his or her own assets.
Thank you for the answer. I would think that the only place that bankrupt can travel now would be Hong Kong, because they are potentially starting that travel bubble. So
that's right.
I guess
we don't have a date yet.
So I guess that's a silver lining. You potentially travel to Hong Kong. All right. So moving on. The next thing that we wanted to cover was so there are potentially some offences that a bankrupt may be liable for. It'll be great if you can just shed a bit of light on this.
Yes. So some of the offences that that one needs to bear in mind would be, for example, not submitting the statement of affairs within 21 days of the bankruptcy order, and failure to cooperate in handing over assets and income, or for example making false statements to the official assignee, traveling without approval of the official assignee. These are very serious offences and could in some cases result in a jail term as well. So it's really in the interest of the bankrupt to take a long-term view of the discharge. Firstly, don't assume it's going to be a given and it's automatic. Yes, there is a governmental policy to try and ensure that bankrupts are discharged at an optimal time, so that, for example, somebody who fails because of entrepreneurial risks should be able to find their feedback in society and become productive active member of society to earn their keep without the long tail of bankruptcy following them. So all of that makes sense, but it's not automatic, and conduct is certainly scrutinized, and you've got to take a long-term view of things the moment the order is made as well. But those are some examples of offences. There are a whole host of other offences as well that are found in the bankruptcy legislation.
All right, thank you for the useful examples. We will now move on to discuss moneylenders in a very brief fashion. So we know that moneylenders is obviously a growing concern today, and we are glad to be able to shed more light on this issue. So could you tell, Greg, could you tell us the key difference between licensed and unlicensed moneylenders?
Certainly. So this is also quite an interesting area. All licensed moneylenders are regulated by the Singapore Registry of Moneylenders, and that is essentially under the Ministry of Law. And there is a comprehensive list of licensed moneylenders in Singapore maintained via the Ministry of Law website, and that will enable anyone that wants to check out whether the person who claims to be a licensed moneylender is legit or not. So you would want to be wise and discerning, rather than to end up in a situation where you're borrowing from an unlicensed moneylender. So now, before you borrow money, of course, check that list. Ensure that you're borrowing from a reputable source and a secure source. If you've got intel about that licensed moneylender, see what you can garner before you get into that obligation. Now, there are also some safeguards if the licensed moneylender is carrying out activities that are dubious or suspicious. You could file a complaint with the Registry of Moneylenders at a hotline number, which is 63251416, or via email at ipto_ROMP, Registry of Moneylenders, and I think it's pawnbrokers, at ipto.gov.sg. So, and essentially, it will be done almost like a whistleblower type of way. It's a channel where you can, be able to speak freely. Personal details will not be revealed to the moneylenders under inquiry without permission from the person sharing information as well. Now, what is important to note is that, and it's just to build on that point, licensed moneylenders or not, it's a question of whether they are still doing illegal things, and you could be an unlicensed moneylender, which of course is, illegal, or you could be a licensed moneylender, but basically engaging in illegal things, which may be exorbitant interest rates and so on. And I mentioned early on in one example that in some of these cases, it may be open to a debtor to, after taking advice, to defend the entire claim on the basis that it was a money lending, it's a money lending defense. So licensed moneylender or not, if the interest rates were excessive and effectively what is known as exorbitant, in terrorism and so on, you might be able to defend against the entire claim itself. But these are rare, they're exceptional. They would require some compelling evidence as well.
Okay, thank you very much, Greg. That leads into what I wanted to talk about next. And these are obviously all the areas that you've mentioned so far, areas that the illegal things that you can you can complain about and make a police report about, right? So, it's even licensed or unlicensed, both of them can be doing illegal things, right? It's just that the illegal one is even worse because they are not even licensed to pursue legitimate money lending. So in all these cases, I would think that it's advisable for moneylenders to then file a complaint with the Singapore Police Force, right? And I think we would definitely encourage you to do so if you are faced with such practices. Okay, moving on. I think we know that there are several policies currently, and I think Greg also made mention of it earlier, that there are several policies implemented to deal with COVID-19. And that's definitely the biggest thing on everyone's mind now. So shall we briefly explore this for a while?
Yes, we can. Yes, certainly there's a lot of, I think, very helpful legislation rolled out by the Singapore government on an almost emergency basis, which shows, the forward-looking and, just thinking 3-4 steps ahead to try and help the business community. And, we know that, one of the initial types of legislation that had been issued, granted relief for certain types of contracts as well, the event and tourism related contracts, for rental relief, for other types of contracts as well, which essentially posited a moratorium on commencing or continuing legal proceedings. So in the case of rent or payment of rent or leases, which are non-residential in nature, there was a moratorium on commencing or continuing legal proceedings for non-payment of rent. Likewise, there was a moratorium even in terms of insolvency to initiate by bankruptcy proceeding by way of statutory demand and so on, or even by way of bankruptcy proceedings because of the extended time that is granted. And the logic of that extended time was to allow for a time frame for landlords and tenants, in the example I've cited, which is leases, to essentially negotiate something that may be more palatable, a plan, to allow for some breathing space and more manageable payments. The underlying theme in relation to these legislations and the moratorium and the type of protections afforded to the parties who are obliged to make payment is that they were unable to pay because this was related to COVID-19, and so COVID-19 was still the cause that would affect that payment, and there needed to be an assessment of that. Now, if for whatever reason there was a dispute whether or not the non-payment was due to COVID-19, then by way of avenues that were created by the government, there is a panel of assessors who would decide on that dispute by way of a determination in order to be fair to both parties. It was binding on the parties, not appealable. There was a flexibility of outcomes that was available to them, but this is the final stage of escalation in the event of a determination. In addition, there were also rental waivers, property tax deferment of 30 to 100%, the job support scheme that has been a great boon. We know that for the legal profession as well. supporting the Singaporean workers' wages up to that cap of $4,500. And then there's also various grants that could be invoked. The companies could apply for productivity solutions grant, and also various other digital solutions in the Go Digital program are available. I won't go into a lot of these details, but I think the effects of all of this was to help the companies and businesses weather the storms, and for individuals to have some breathing space, and to be able to come to terms, cope with, and to have deferred payments. I mean, if we talk about the moratorium that I spoke about, which is essentially a kind of temporary freeze, everything kept in a state of suspended animation. All it does was to block the remedies of, for example, the landlord or the vendor from pursuing court proceedings or initiating bankruptcy proceedings and the like. But it didn't affect the rights, so the debts are snowballing until the expiry of this, and all of this could break the back of an individual, which is why I think the government has, I think, wisely been initiating this micro liquidation and also micro restructuring options for people that are unable to carry on the sustainability questions. They can close shop in a way that is fuss-free and with minimal costs and in double quick time.
Thank you very much, Greg. Okay, so basically we have covered quite a bit on how the government has been trying to help people avoid bankruptcy, right? So just circling back to the question of ending bankruptcy, because I think we have spoken a lot, we have spoken very briefly on discharge. So maybe if we could do a quick summary of the ways one can be discharged as a bankrupt, and then also cover a little bit of what alternatives there are to bankruptcy, that might be quite helpful for our listeners.
Understand. Okay, so we go back to the end. This is what the slide says. Sure, how does it end? How does it all end? And in a sense, it's a glorious moment when an undischarged bankrupt becomes discharged. But analytically and technically, there are two ways. You have an annulment route and you have a discharge route. An annulment route is when the undischarged bankrupt is able to repay all their debts in full, plus interest as well, and make, in some cases, an arrangement that's acceptable to a majority in number, amounting to 3/4 in value of the creditors. The effect of annulment, unlike a discharge, is to wipe the slate clean. Effectively, it removes that bankruptcy status from the records. It's as though you turn the clock back and you unwound the entire bankruptcy. It's as though it never happened, So that's annulment, but those are rare, really rare type of cases. Of course, with an amount of $15,000, it's still plausible, $15,000 being the threshold amount, leaving aside the COVID numbers. We know that that is already something that could still, in a moment of very tight liquidity, result in bankruptcy in some cases, but then the person may recover by way of third-party funding or family chipping in, and then pay off and then go for annulment. Discharge is the more conventional route. The bankruptcy order can be discretionarily discharged by virtue of certificate of the official assignee, and so that will involve the official assignee applying its discretion, provided at least 3 years have elapsed since the commencement of the bankruptcy and the proven debts do not exceed $500,000. And so in deciding whether to issue the certificate of discharge to the bankrupt, the official assignee will consider aspects like cause of bankruptcy, period of bankruptcy, the regularity of installment payments, the bankrupt's assets, the bankrupt's conduct, bankrupt's cooperation, and whether or not the creditors object to the discharge itself. Those are all factors that will be considered. And there are also other fixed points in time. So it could be 3 years, then it could be 5 years, could be 7 years, depending on quantum. I won't go into a lot of technical detail now, but it's open for that type of option to be considered. Even if the contribution is not paid in full, there will still be a regard for what the bankrupt was able to do reasonably. If the target contribution was paid in full, a bankrupt's record will be kept on the register and publicly available for 5 years. Otherwise, the bankruptcy record will be made available permanently. And so that is, of course, the hope, that it will be a permanent wipeout, and essentially it's like the right to be forgotten, to sort of put it in a much higher level of abstraction. Now, in terms of alternatives to bankruptcy, just to cover that quickly, there is something known as the debt repayment scheme, where the High Court could assist debtors who fulfill certain criteria, because this is really like a working debtor proposal, where the debtor has got regular income, and there is unfortunately a ceiling of $100,000. The debts cannot exceed that amount, and they will have to be repaid over a 5-year period. So if you're in the DRS zone, that could be one avenue to consider for anything under $100,000 or less. Then there is the individual voluntary arrangement, where an interim order can be made to accord the debtor respite from legal proceedings, to give him an opportunity to put forth debt settlement proposals for consideration by the creditors. A majority of creditors holding at least 3/4 in value of the debts owed have to accept the debtor's proposal. So those are alternatives that could be considered as well.
Thank you very much, Gregory. Those are very good alternatives to consider. We have a second scenario for our listeners, so that they will better understand the content that we have covered so far. So this scenario basically is, and I'll read off quickly: a small and medium enterprise, or SME for short, selling food has cash flow problems as business dropped sharply due to the COVID-19 pandemic. The SME is now struggling to pay their rent and workers. So this scenario is probably very common right now during the pandemic. What happens when an SME faces cash flow issues? And how can they tackle it, I think, is the lead-on question.
Yes. So, of course, in this case, it's important to note that we're talking about an enterprise, right? We're not talking about an individual. And so for this, the assumption is that we are speaking about a company that, it has been incorporated. And a company will, of course, be registered under ACRA, and will essentially give rise to an artificial legal person, which is the company itself, which has a separate legal personality from its controllers, which are the directors, and a separate legal personality from its owners, which are the shareholders. And of course, there's limited liability on the part of the individuals who are shareholders and directors for the debts of the company. So company faces these cash flow problems because business drops sharply. And so if it's a liquidity issue, of course, you might be able to get credit lines, to tide over, or you've got credit lines that you might be able to draw down on, but these are all temporary, sort of financing, and you need to consider the wisdom of that. And of course, you will want to ensure that you're paying some of these essential payments for like rent, and of course staff salaries, because without that, you can't carry on. You don't have a roof over your head, and you don't have people to carry out the business, to work in the business. So I think that's liquidity. Now, as you move towards insolvency, because a lot of creditors are owed money, then the company will, and the directors of the company will need to seriously consider and have regard to, can you really carry on as a going concern? And if you cannot, then you need to bear in mind that as the company plummets to insolvency, what is in the interest of the company will become synonymous with the interests of the creditors, no longer of the shareholders. And so you would have duties that you owe to the creditors as well. And so COVID-19, the pandemic, of course, has surfaced these types of issues. And the SME will need to see whether, is this a temporary blip? For example, was this because it was during the circuit breaker period But now as you move into phase 1, phase 2, potentially phase 3, it will be on an upward trajectory, and so you are able to have weathered the storm, become resilient, sustain, and carry on. It's just a temporary blip. But if you cannot be solvent despite all these support measures that the government has rolled out. We touched on a little bit of that. There's a lot more, of course, that the government has done. Measures that trade associations are doing, and even with other types of funding and so on. Then you have no choice but to ask yourself, can you save this business that is insolvent, that you acknowledge is insolvent? And by insolvency, I mean unable to pay your debts as and when they fall due. And there again, we can get technical. It's either because the liabilities overtop the assets, so it's balance sheet insolvency, or it's commercial insolvency because you're unable to pay your debts as and when they're falling due commercially. So when you acknowledge that, you either go down the rescue route or you go down the liquidation route. So you either have hopes to rescue this company, and you would do it, for example, by way of one of the ways, judicial management, where you have got some temporary shelter because you would apply to court to give you that umbrella of protection, so nobody can bring in a legal case against the company. But you will need to not only acknowledge that the company is insolvent, you also need to be able to see whether a statutory objective for judicial management can be realized. For example, a more advantageous realization than the breakup of the company, or for instance, if you can save all or any part of this company as a going concern, or there is a plan that you can put into place, a kind of scheme that you can put into place, in technical parlance. And so, if that's available, you satisfy the court sees that there is hope. For example, there is a core business that is worth saving, and some of the plans may involve hiving off the non-core business. Or, for example, there is some key asset that could be fetched, could be realized at a great value, and that could result in money flowing in, or other things that are just more cyclical, and you might overcome it rather than more systemic. Then these are options that can be considered, the judicial management route, and that is essentially debt restructuring. It will involve an independent judicial manager being appointed, so the powers of the board get transferred to the judicial manager. The judicial manager, who will typically come from an accountancy firm, will manage the affairs, business, and property of the company under financial distress. It will be a rescue operation, and so that's what it is. It's rehabilitation. It's rescue. Now, if you cannot rescue, then you're going down the liquidation route. The liquidation route is the funeral service of the company. And so, unfortunately, there are companies that have no choice but to go down this route. And so here, there are options to either wind up the company voluntarily or wind up the company compulsorily. Voluntarily would be, for example, creditors' voluntary liquidation, where the company is ascertained not to be able to pay its debts in full within that foreseeable future after basically it's unable to pay its debts in full. If it's able to pay its debts in full, I should say, then you would go down what is known as a member's voluntary, but that's not the situation we're talking about, because we're talking about a cash flow problem giving rise to insolvency, and therefore a creditor's voluntary liquidation. And that's managed consensually. It's managed by way of the choice of the creditors for whom they want the liquidator to be, trumping that of the members. But in many cases, the company may not initiate it. They either may not be self-aware. There's still a sentimental attachment to the company, and so the creditors will have to force the issue and apply to court. And so that's what we call compulsory winding up. Creditors apply to court, wind up the company, and in an analogous process to what we talked about in bankruptcy, they will initiate what is known as a statutory demand, which they will then rely on once it is not honored within 21 weeks from the issuance of the statutory demand. Rely on that as an evidential presumption of inability to pay, to then bring the winding up case, and then the winding up case or the winding up application, once it's brought to the hilt, the company is unable to pay, it will result in a winding up order being made, but the date of commencement of winding up will date back to the date of the winding up application. And so when you reach that scenario, you will obviously end up in a situation where the company is in liquidation. There's a liquidator appointed, and the liquidator will then manage the affairs. It's analogous to the trustee in bankruptcy that we talked about earlier. They will basically take control of the assets where there are assets that are not monetized, illiquid assets. They will then realize it, bring the money in, and then start paying off the creditors. And there is usually a priority of creditors that you will need to consider. So in order of repayment of debts, it will be first the liquidators. So unfortunately, the professionals' fees are in that sense given priority by way of their own costs and expenses. And it makes sense, because if not, why would you even do the job? Then secondly, the employees who are considered to be preferential as well, like the liquidators. There'll be retrenchment benefits, work injury compensation, all of that, and there are also capped amounts are listed in the legislation as preferential debts, and they will be paid ahead of all unsecured creditors. Secured creditors will of course seize the property under, which is their security, realize it, pay themselves, and if there's a shortfall, prove as unsecured creditors. But the unsecured creditors will be paid after the preferential creditors, and they queue up, and whatever's left is shared pari passu among pro rata among all those creditors. How many cents to the dollar, they will just get that, and that essentially will be all that they receive by way of returns. So that's the way it usually plays itself out. It's either rescue or the funeral service.
Thank you very much for that very comprehensive response, Gregory. I think, and also of course, thank you overall for this very informative session. I think let's also see if there are any further questions on this session. And as a reminder to all our participants, you can still submit questions through the questions pane on your screen. Currently, we don't have any questions, but I do have a question, and I think might be quite relevant for our listeners. Just leading on from the scenario, right? As you were saying that, there's obviously a rescue option, which is judicial management, and then obviously there is also liquidation, which is the final resort, so to speak. If you were to wound up your company, would you typically require a law firm to represent you, or is this something that you can file yourself? I think that's something our listeners might want to know as well. I mean, some of them might be in the fortunate situation of having their small companies in a very insolvent state, and I don't think they may have much funds to afford professional advisors. So they might want to hear a little more on that. Of course, being a very unfortunate situation.
Yes. So I think, and so we're speaking about the debtor itself, and whether or not they need to hire lawyers, to put it a bit more directly.
That's right.
Yeah. And so from that point of view, I think it's all about again a pragmatic consideration of the matter, because in some cases there may be merits to resist, for example, a compulsory winding up or compulsory liquidation, and so you would want to have sound legal advice on whether or not, for example, there might be some technicality, or there might be a reason to oppose a debt that might be disputed. And so for that, you should take legal advice, and if there are merits, then of course you would want to have the lawyer represent you.
Thank you very much.
Now, yeah. But
sorry,
in other cases which are clear cut, then I think other cases that are clear cut, the writing's on the wall. No lawyer can help you.
Okay, so sorry because I actually have it just come to my attention that there are a few questions that are coming in now. So
Okay.
just give me a second. Okay, so someone asked this question. Is it true that you have to pay $1,800 to declare yourself a bankrupt? That seems very specific. I mean, but it seems like this person is truly concerned. If you could answer that, that would be wonderful.
Um, yeah, that's an interesting point. I think that is the deposit to the official assignee number, but I need to double check that, I confess. I think that is probably the deposit. Now, if you engage a lawyer, of course, for a debtor's application, then you would be having to pay the lawyer's costs as well. And yeah, I think we confirmed that there's a deposit of 1,850 to the official assignee. So that is only the deposit. It doesn't include other things like, for example, the cost, the costs involved in the filing, the oath fees, all those disbursement items, leaving aside the question of supposing you engage a lawyer, the costs that the lawyer will incur.
Okay, so another question that has arisen is basically how do you deal with assets when because there was a bankrupt and we were talking about how assets are being dealt with in bankruptcy. What happens if the bankrupt inherits property following the death of a relative? So is he and he's a bankrupt. So the question was, is he still allowed to inherit property as a bankrupt, or would it just automatically be seized by the OA?
Okay, that's a good question. And so I'm going to reason this out from first principles, because I think as long as you're an undischarged bankrupt, then all your assets, all your property vests in the official assignee. So as at the date of the order, everything vests. I think there are some interesting technicalities involving what is known as after acquired assets. And so for after acquired assets, for example, if it's something that you have received after the bankruptcy order, then I think it might come in two ways. I think at a practical level, of course, you would then have the means by reason of that inheritance to be able to pay more into the bankrupt's estate. So at a practical level, it could come in that way. But I think the issue of after acquired assets, I think if I were to reason it out on first principles, it seems to me that still as a matter of law, they ought to vest in the official assignee nonetheless, And so what you need to do, is to disclose it to the OA.
Okay.
And for as long as
course,
you are, yeah.
Yeah, of course, noting also that those are subject to the same exemptions that you were saying earlier. I think regarding HDB flats, right, and CPF monies, those
Absolutely.
exemptions will still apply. All right, thank you very much,
Absolutely.
Greg.
Yeah.
One very interesting question as well is regarding insurance policies. So someone has actually asked, does a bankrupt need to give up or cancel his insurance policies? I think this is a key concern for this person, so it might be good to elaborate a little bit on this.
Yeah. So in terms of guarantees and other types of loan agreements, I mean, essentially everything comes to a grinding halt the moment the bankruptcy order is made, and so in that sense, you would be wise at a practical level to notify the people that you owe money to, that this is the status now, and so you're unable to service any of these loans, and or likewise, if you're a guarantor and that obligation hasn't arisen as a secondary obligation because the primary obligation hasn't been triggered, in order to see the secondary obligation as a guarantor arise, I think it's wise for you to give notice that, look, you're now a bankrupt, and you wish to be discharged from the guarantee obligation. And as a matter of law, it also probably constitutes a type of material alteration, for the purposes of even the obligation being guaranteed. From that point onwards, as a supervening event. So it seems to me that from the perspective of just prudent management of the matters, you should notify the creditor in whose favor the guarantee is given, or even the creditor to whom you owe that money to, that, look, this is the status now, and you are unable to pay. And I think that's also a prudent step, because then it will stop that person from hounding you if they don't already have notice of your bankruptcy status. But once they have noticed, what they will do is they will just file proofs of debt with the bankrupt's estate. Go to the official assignee and public trustee's office, who will then manage that. But rather than ask you for money. So it is a prudent thing to do if they aren't already notified.
Understood. So basically, just to sum it up, basically it is prudent to notify your insurance agent or your insurance policy holder, insurance company, right, that you are bankrupt, and then maybe some further decisions that are made after that, as I understand.
Yes.
Okay.
So that's asset. Those are the asset points. And of course, that will be something you will need to disclose in the statement of affairs anyway.
Understood. Okay, something interesting as well that has been raised by one of our listeners. There's a question about this debtor owing over $100,000 to licensed moneylenders and passing on. And so I believe the question is, will his spouse and children be made liable to pay off his assets in that situation?
Right. So the claim is personal to the debtor concerned, and so a money lending claim of that nature, assumption being that this is not illegal money lending or a licensed money lender engaging in illegal activities, such that the defense of money lending becomes a complete answer, but that this is lawful money lending for which there's a legitimate debt which needs to be serviced. And so the individual passes on, and so the claim then becomes a creditor's claim on the estate of that individual. It doesn't reach out or extend to the family members. Family members are not liable to pay for the debtor's obligation even if the debtor is deceased. So what will typically happen is, they will claim from the estate, and the estate will need to pay off all these creditor claims first before there's anything left to be distributed to the next of kin. So it will only affect the debtor and his or her estate when they pass away. It will not be visited upon a family member.
All right, thank you very much, Greg. I think the same person who asked the same question actually had a clarification point and raised it in the box as well. And I think the clarification was, if let's say, because remember we spoke earlier about the HDB flat being exempt, right? So if let's say the debt applies to the estate and the HDB flat is part of the estate, will the people who are still staying in the house, okay, assuming in this case that the flat is jointly owned, right, or jointly owned by the spouse and the husband who passed away, then would that be the case that that flat is exempt from the claim on the estate because of the general exemption on HDB flats? Just a quick answer will do actually on this.
Yeah. Short answer is yes, and at two levels. One's the general exemption, two is the doctrine of survivorship. So the joint owner gets everything.
Okay, we will end this with a Somewhat funny question. Someone actually asked, if he becomes a monk, is he now free of his debts? Yeah, that's the question actually.
Maybe he might translate the financial debts for some moral debts or spiritual debts, but no, that's just tongue in cheek. Well, I don't think even if you have a radical change of lifestyle and you're pursuing a more enlightened path, or entering into a religious order, becoming a monk, etc. Or even any other religion, that will somehow wipe the slate clean from a financial perspective. A debt still follows you wherever you go. And of course, if there's an interest element, then that's just going to grow and grow and grow and grow, and it just adds on to the debt. And so one still needs to confront this. I mean, the sensible option is to try and see whether you can have some kind of compound or compromise, or some type of deferred installment payment, or if you need to see if you can practically borrow from a family member or friend to pay off, because once you do, at least you stop the interest. I mean, you're taking an interest-free loan, and then you can repay that family member, hopefully on an interest-free basis. And that's, of course, dependent on the goodwill and the kindness of people involved, family members and friends. But those are some of the practical ways. But no, I'm afraid not. You will not be lightened from that burden. Maybe enlightened in other ways, but you will not be lightened from that burden.
Okay, thank you very much for that. So unfortunately, given time constraints, we have to bring our Q&A session to a close. Please remember to download the useful handouts regarding the issues discussed today. Again, they can be found at the Files tab on your screen. We hope you found our webinar on dealing with creditors useful. Your feedback will help make future webinars more relevant and useful to you. Once you leave today's webinar, you will receive a survey, and we will appreciate your feedback on today's session. The General Credit Counseling, or otherwise known as Credit Counseling Singapore, allows one to seek information on debt management, obtain credit counseling, and get help to work out debt repayment schemes. Their phone number is 6225-5227, and their website is ccs.org.sg. Okay, so this is another possible avenue to explore to see if you can get a better outcome in managing debt. Thank you very much for spending the evening with us. On behalf of Law Society Pro Bono Services, thank you for joining us today, and have a good evening.